Good afternoon, everyone. Welcome to today's webinar, Not So Casual, the ins and outs of casual employment. We're just going to wait a few minutes just to give people time to jump into the webinar. So just hang tight and we'll begin shortly. Looks like we've got a good amount of people who've jumped in so far, so happy to get started. Ladies and gentlemen, a very warm welcome to you all. We appreciate your time today. And today we'll be doing our very best to make sure we're shedding some light on the nuances of casual employment. Throughout today's presentation, I'm sure you'll have a lot of questions, so we'll go through them at the end of the webinar. I highly urge you to use the Q&A function on Zoom rather than the chat so we can actually see your questions. So as you can see with today's title, Not So Casual, the ins and outs of casual employment. We picked today's topic as it's one that's always been in high demand, especially in the current environment. And we always get questions around casuals and managing them properly. We understand sometimes it's unfortunately quite difficult to ensure you're completely up to date with all the legislation changes and the complex laws around employment in Australia. So hopefully today we can address any questions or doubts you have around managing casuals and just help you so that you're more informed or as informed as possible after today's session. Before we get started, I'd like to introduce you to today's speakers. On the right, that's me. I am Anu. I'm a business development coordinator for HR Assured. And on the left, you will see my colleague Katerina, who we're lucky enough to have today. She's going to present today's information and answer your questions. Katerina is a senior workplace relations consultant and a core member of our advisory service. So today she'll be walking you through today's topic and guiding us through understanding the ins and outs of casuals. On the next slide, there's another introduction I'd like to make. For those of you who aren't familiar with our family, on the screen, you'll see current members of the FCB family. There might even be some names you haven't seen there before. So starting off on the top left, we have FCB Workplace Law, which is one of the leading specialist employment law firms in Australia. FCB Workplace Law is pretty much where we get the backbone of our expertise in employment law. Right next to that, you'll see FCB Smart Visa, our immigration and migration practice. If we jump to the bottom left, you'll see Enable HR, which is our in-house proprietary technology solution. Basically exists to help you manage your HR and health and safety on a cloud-based system to make things easier and less complicated to do on a day-to-day basis. Next to Enable HR, you'll see QMS and Best Practice, which are our certification services. They're the newest members of our family. They'll be able to help out if you are looking for getting ISO certification for your business, as well as NDIS certification under QMS. But the banner in which we're talking to you today is HR Assured. So at the top there, you'll see that our slogan is avoid admin, create the culture. So HR Assured is an outsourced HR solution, and that is the best way in which we support businesses. So most of you who are here today probably have some sort of responsibility around the HR side of business. So you know that you probably didn't get into that position to look after all the legislative requirements and all the admin that comes along with managing staff. So HR Assured basically exists to take as much of that off your hands as possible so you can spend your time on more impactful things to the business, like your business strategy and your workplace culture. How we do this, when a client comes on board, the first thing we do is we do a comprehensive HR audit. That's to help diagnose parts of the organization that need assistance. From there, any critical areas of non-compliance are things we jump on straight away. And then we'll also work with you to plug any holes that we identify so that the business is following best practice. You also have access to our advisors 24/7. Basically, this allows you to have a professional at your fingertips. So if you ever run into a tricky situation or you need someone to help you navigate through a difficult time, you'll have someone there to assist you. You also have access to the HR software I mentioned earlier. So again, to help make things less complicated and easier to manage in your day-to-day. You have access to our legal library of resources. And most importantly, you also have the backing of FCB workplace law. So you just have that extra layer of confidence if everything before didn't give you enough. With that in mind, I'd like to hand over to Katerina to take us through today's agenda. Over to
Thank
you.
you so much, Anu. So guys, welcome. In today's session, we will be covering all things related to casual employment. And first off, we'll be kicking it off by stepping through the key factors which make a casual employee a casual. We'll then be looking into what entitlements casual employees have. So there is often a misconception that casual employees have no entitlements whatsoever, but I will debunk those misconceptions there and step you through some types of leave which casual employees are in fact entitled to. Thirdly, we will be discussing the obligations for businesses surrounding casual conversion and specifically the eligibility criteria casual employees and businesses are required to meet. And lastly, we will of course have time to answer any questions you guys may have, either relating to casual employment or any other employment relations-based questions you guys may think of during this time. So stepping through what makes a casual employee casual. As many of you may be aware, casual employees do differ from permanent part-time or permanent full-time employees, but the question is how so and what in fact makes a casual employee casual. So firstly, a person is a casual employee if they accept a job offer from their employer, knowing there is no firm advance commitment of work and there is no agreed pattern of work. So for example, where an employee has their roster changed from week to week to suit the employer's needs or the business's needs, and where that casual employee requires that flexibility to also be able to change their own hours, they can refuse or swap shifts accordingly without the need for any additional paperwork or variations. Moving on, I guess there's an elusive term here, no firm advance commitment of work. And as you can see, there are 4 factors which determine whether an employer's offer does not include a firm advance commitment of work. So firstly, whether that employer can choose to offer the employee work and it's the employee's choice to work or not. So, you know, they put out a roster that employee is required to work Tuesday, Wednesdays according to that roster. Generally, that casual employee will have the option to actually pick and choose whether they'd like to work it. There's flexibility for them to swap it according to their own needs. And also the same goes for the employer. Secondly, it's whether the employee is offered work when the business needs them to work. And I suppose the most simple example in this instance is a Christmas casual. Thirdly, if the employment is described as casual employment, and this refers to the provision of their employment contract and the nature and structure of that employment contract. Lastly, if the employee is paid a casual loading rate. So this loading rate is a base rate of pay that is higher than what a permanent employee, so a full-time or a part-time employee would receive. And this casual loading rate is usually prescribed under a modern award. Usually and typically it is 25%. And the reason this casual loading is implemented is to compensate them for the lack of other entitlements that they may not receive when compared to a permanent employee. So annual leave is the simplest example, as well as paid sick leave. And the difference in the casual employees' entitlements is obviously something that we will step through as we go along through the webinar today. Moving along, how is a casual different to full-time or part-time? So the key differences between a casual and permanent employees is that they have an advance commitment to ongoing employment. This means for a part-time employee, they do generally have their hours agreed to in writing, usually within their employment contract. They will agree to certain days that they work and certain times they work on those days. When compared to a full-time employee, there's usually a set 38-hour they're set 38 hours per week. Of course, that full-time employee can choose to work additional hours where it's reasonable. And again, this is often something that is agreed to in writing before they commence. Moreover, permanent employees do have access to paid leave entitlements. So that's things such as annual leave, of course, and also personal carers leave. That's also known as sick leave. And permanent employees do need to give notice under the National Employment Standards, the Modern Award, or whatever's contained within their employment contract if it's anything different. So these additional factors are really important to note because just having a regular pattern of work doesn't always mean typically that they're going to be a permanent employee. There's additional background factors that also weigh into that fact as well. So looking at the casual employees' entitlements, there are a few different things that they are entitled to. And as you can see on the slide here, they are entitled to access a pathway to become a permanent employee. And this is known as casual conversion, a process which we will, of course, look into shortly. They do also have access to 2 days unpaid carers leave and 2 days unpaid compassionate leave for every occasion that they may require that. So the eligibility criteria for this leave is the same as that for permanent full-time and part-time employees. So compassionate bereavement leave is something that other people may refer to it as. The two terms are interchangeable, but both permanent employees and casual employees have this entitlement. At the moment as well, all employers do have 5 days of unpaid family and domestic violence leave in which they can access in a 12-month period. This is currently the entitlement, but it is important to note that there will be upcoming changes to this entitlement available to all employees, and this is also including casual employees. So on the 28th of July this year, the government did introduce a bill to create a uniform entitlement to paid family and domestic violence leave, and this is being inserted into the National Employment Standards. These changes are expected to come into play on the 1st of February 2023 for large businesses, and small businesses will be given an additional few months to put that into effect, and they'll have until the 1st of August 2023 to ensure compliance with these changes. Essentially, the nature and operation of this bill regarding the leave slightly differs from the decision that was initially handed down by the Fair Work Commission earlier this year. So firstly, this leave will be available, as I've said, to all types of employees, including casuals. Initially, it wasn't supposed to include casuals, so that's just an important factor to note there. Secondly, this leave is not something that accumulates from year to year, but it will be available upfront. So this essentially means the full 10 days of paid leave is available to every employee at the start of every year. And lastly, the leave will be payable at the rate the employee would have earned had they worked that particular day instead of taking that leave. So this includes any loadings that they may have incurred or penalty rates they may have incurred when working that particular shift. This does make it a unique form of leave compared to other types of leave. Just essentially when an employee is away on annual leave, they just receive their base rate of pay, usually with annual leave loading, regardless of whether they were working a Saturday and were going to incur penalty rates for that specific day. An additional form of leave available to casuals is unpaid community service leave, again, also available to permanent employees. And an interesting one to note, and something more recent that's come into effect, is the Victoria Sick Pay Guarantee. So this initiative is state specific and it is only available to those casual employees in Victoria. This initiative is currently running for 2 years and it kicked off on the 14th of March this year. So only employees in certain jobs and certain industries have access to this entitlement. And before an employee does make a claim for the Victorian Sick Pay Guarantee, they need to sign up through Services Victoria, and Services Victoria will undertake an eligibility assessment as well. Furthermore, casual employees can also request flexible working arrangements, and they can take unpaid parental leave if they meet the certain criteria. So that criteria is quite similar to what it would be for a permanent employee. So they need to have been employed as a casual employee with a regular and systematic pattern of hours for at least 12 months with the business. And there needs to be an expectation that their employment will continue on a regular and systematic basis upon their return as well. So just moving along here, what don't casual employees receive? So they don't receive paid days off. So sick leave is one of those, obviously excluding the sick pay guarantee. In every other state, and for those who don't meet the eligibility criteria for sick pay guarantee, they don't receive a paid sick day off. Secondly is notice of termination, both upon resignation and termination. So usually a permanent employee would need to provide 4 weeks notice by way of example upon their resignation, but this isn't something that casuals need to give, and they can resign or be terminated effective immediately. Thirdly is redundancy pay, which is self-explanatory, I suppose. So when a business undergoes redundancy, they generally need to pay permanent employees who are eligible a redundancy package, but casual employees don't receive those. And lastly, long service leave. So it is in some instances that they won't be eligible for long service leave. Generally though, all states and territories provide for long service leave entitlements for all types of employees, but this doesn't necessarily mean that they're automatically going to be entitled once they reach that those certain number of years of service. So in order to be eligible, employees need to have had a period of continuous employment with their employer. And of course, as many of you may be aware, this isn't always the case for casual employees. Sometimes a casual may remain engaged technically on the books with the business, but they may not have worked any shifts for, a period of 3 months, 4, 5 months. And in instances like this, where there's usually a break in between their shifts, and that break is quite extensive, it would be deemed to be a break in service, which then affects their eligibility to receive long service leave. Usually, though, the definition of a break in service and continuous service is different in every state and territory, and it is prescribed for in the relevant state or territory's legislation. So if you do have any specific questions relating to a casual, you can always use the HR advisory line just to check what those legislative requirements are. And just moving along.
Thanks, Katerina. I know we've covered a lot of content already. I can see from the question and answer section, a lot of you have some questions that you're looking for some guidance around. We'll cover as much of these as possible at the end of the webinar. In case we don't get to everyone's questions, because there's a lot coming through, or even if you have something a bit more sensitive, on your screen, you can see a QR code for you to scan. So if you have questions around casuals, what we're talking about today, or other HR matters that you're struggling with, definitely make use of this. So just pull out your phone and scan this code, and you get to actually try out the 24/7 advisory service that our clients use, and actually speak to a workplace relations expert. There's no obligation either, so great opportunity for you to speak with a professional. I'll give you a minute to give you enough time to scan the code so you guys can actually make use of that. Hopefully that gave you enough time. But yes, back over to you, Katerina.
Thank you, Rennie. So casual conversion, it can be quite tricky to navigate, particularly because there are so many, there's so much in terms of the eligibility criteria that comes into play. So we'll step through this with you now. So becoming a permanent employee, as I've said, this is a pathway that is accessible for casual employees. And generally a casual employee remains engaged as a casual employee until they either become a permanent employee or when they are offered the casual conversion option. So a casual employee can change to full-time or part-time at any time throughout the course of their employment if there is an agreement between the employer and the employee. So what is casual conversion? Just moving along here, under the national employment standards, casual employees are provided with a pathway to become a permanent employee, and this pathway and process is known as casual conversion. So casual employees who have worked for their employer for 12 months need to be offered the option to convert to full-time or part-time permanent employment by their employer. And before stepping through this eligibility criteria, it is important to note that small business employers, so those who have fewer than 15 employees, don't have to offer their employees the option to convert. However, a large business, so those who have more than 15 employees, they do have this obligation here. An eligible casual employee working for a small business can request themselves to convert to permanent employment at any time on or after their 12-month anniversary with the business. And to respond to an employee's request to convert to permanent, employees need to write to them within 21 days and tell the employee if they have or haven't accepted their request and the reasons as to why. If the employee does refuse the request, they have to tell the reasons why, of course, but it needs to be in a written response. And employees can't refuse a request unless they have consulted with these employees, and there are reasonable grounds for this rejection as well. So what happens when an employer offers casual conversion? So those large businesses who are obliged to offer casual conversion, the following eligibility criteria needs to be met. They need to make a written offer to the casual employee within 21 days after their 12-month anniversary if the employee has been engaged for the last 12 months. They've worked a regular pattern of hours on an ongoing basis, at least for the last 6 months, and they can continue to work these hours as a full-time or part-time employee without any significant changes to the hours that they're currently working. And the offer needs to be for the employee to convert to full-time employment if the employee's hours worked for the last 6 months do resemble or reflect that of what a full-time employee would generally work, or alternatively, a part-time employee if their employment and their hours worked is consistent with that of a regular pattern of hours worked. So, for example, if they're working every Monday, Tuesday, and Wednesday, it could be something to consider when offering them permanent part-time employment as well. To find out whether an employee's hours are full-time or part-time, it's important just to check the relevant award or the agreement if the employee is covered by one, or the hours worked by your full-time and part-time employees within your own business, and just comparing what that casual is more closely aligned with there. So responding to an offer. So to accept an employee's offer to convert, for an employee to accept an employer's offer to convert, they need to respond in writing within 21 days after obtaining that offer. And if they don't respond, then an employer can generally assume that they've declined that offer for casual conversion. So looking at employers not making an offer. So if an employer, of course, aside from a small business employer, decides not to offer casual conversion, the employer needs to write to the employee within 21 days after that employee's 12-month anniversary. And in that letter, it needs to specify the reasons they aren't making the offer of casual conversion. Generally, the rules surrounding making an offer of casual conversion can be quite stringent and difficult to navigate. Just by way of clarity and as a bit of a breakdown for you guys, the only reasons for not being able to make an offer to a casual employee is if, of course, the employee hasn't met that 12-month mark, if they haven't had an ongoing pattern of work for the last 6 months, and where converting them from a casual employee to a permanent employee would lead to significant changes for the employee's rostered shifts, or if it would significantly impact the business. There are also additional reasonable business grounds that may be considered. It can be quite difficult to undertake a deep dive analysis of these reasonable business grounds because, of course, it does really depend on the business itself and the circumstances surrounding the business. So if you're unsure of whether or not your employees are eligible for casual conversion, you're not sure how this may impact the business, of course, give one of our consultants a call and we'd be more than happy to assist. Stepping through employees requesting casual employment. So they can make that request after they've hit their 12-month mark, and they have up to 21 days to make that request. They won't be eligible, however, if they've refused an offer from their employer to convert to permanent employee. If the employer has told them in writing that they won't be making an offer of casual conversion because of those reasonable business grounds, or if their employer has refused another request for casual conversion because there was a reasonable business ground to refuse that request. Casual employees who do believe that they are eligible to become a permanent employee can make a request for conversion every 6 months. And sometimes employers can still make a request even if the employer has told them in the preceding 6 months that they weren't going to be eligible. But employers can only do this if they think they didn't get an offer because they hadn't worked a regular pattern of work. And since that time, it's changed. They are now working a regular and systematic pattern of hours. So what happens after an offer or request has been accepted? So if a casual employee accepts an employer's offer to convert, they need to then confirm this information in writing to their employee within 21 days after that employee accepts the offer. This can be in the same notice as when the employer tells the casual employee that they are accepting their request as well. So the start date for the permanent hours is on the first day of the first full pay period after that employer has written to their employee informing them of this change, and when that agreement is made between the employer and the employee. So by way of example, if an employee's pay period ends on a Tuesday and the employer writes to the employee on a Friday, then the start date for their permanent hours would then be the following Wednesday. If a casual employee converts to permanent employee, they will be a full-time or part-time employee, even if a contract or other agreement entered into when their employment started says that they're a casual. Generally, best practice would be to then issue them a new employment contract when they do convert. But yes, however, generally, if that, for whatever reason, that contract isn't altered or offered to that employee, it still goes by the date of their agreement. Looking into reasonable grounds for not making an offer or refusing a request, there are generally some reasonable business grounds, and these may include the employee's position won't exist in the future, if the employee's hours of work will significantly reduce. So let's say at the moment they're working 25 hours a week and you only have a certain amount of part-time hours available to them that may halve the amount of hours they're able to work. That would generally be a reasonable business ground in the circumstances. Again, where the employee's days or times of work will significantly change. So if you only have availability for ongoing permanent employment on, the latter half of the week, let's say Wednesday to Friday, but that employee would usually be comfortable working a Monday and a Tuesday, that would also impact the ability to make a casual conversion offer. Additional reasonable business grounds can also include where making that offer would not comply with the recruitment or selection process required by the Commonwealth, state, or territory law, and where the employee would have to make a significant adjustment to the employee's work hours. There are also protections offered to casual employees at work. So, for example, an employer can't deliberately change their employees' roster so that they don't meet eligibility criteria, and so they can avoid actually needing to ask for or offer casual conversion to those employees. Casual employees are, of course, also protected against adverse action by an employer. They do have workplace rights to convert to permanent employment, and where an employee does request that, the employee can't be adversely impacted, such as a termination process, because there's no availability for them to become a permanent employee. Rather, that conversation just needs to be had between the employer and the employee, informing them of the reasons why permanent employment isn't available for them. But they should be kept on as a casual in those instances, rather than just being terminated. In addition to this, regular and systematic casual employees do also have protection from unfair dismissal as well. And there are some disagreements about casual conversion that can arise. So workplace problems can usually be fixed quite quickly when employees and employees work together to come up with a solution. And where that problem is unresolved, they can seek further assistance from the Fair Work Commission. And in some more extreme circumstances, the Federal Circuit Court can resolve these casual conversion disputes. If there is a disagreement about an employee converting from casual employment to permanent employment, they do have access to the dispute resolution procedures set out in their modern award or their enterprise agreement if they're covered by one, and that usually specifies ways to deal with disputes under the national employment standards.
Thanks, Katerina. That was really informative. Before we go on to the questions we've been receiving, happy to offer you a chance to book in a complimentary HR health check. I'm sure a lot of you know what it's like to have too much on your plate, to have really step back and have a good look at where the business currently stands. And it can be really difficult to, in general, just make sure your business is up to speed with best practice, especially as you can see, it does tend to change. It's a great chance for you to actually have someone external work with you to uncover any risks that the business might be facing. And that's the first step in making sure you're mitigating any unnecessary risks that need to be addressed. So again, if you grab your phone and scan the QR code on your screen, you can actually book the HR health check. And at the end of the health check, one of my colleagues will actually give you a detailed report which outlines the areas of concern and how you can actually rectify them. So definitely a lot of value. There's also no obligations to the health check either, so really not too much to lose there. But understandably, we can only do so many of these, so highly recommend that you actually make use of this opportunity. Just a great chance for you to walk away from this being more informed on where your business stands right now. And yeah, at the end of everything, we'll send through the webinar and all the details. We'll definitely have a few of our colleagues reach out to just make sure you don't have any areas of concern or any questions. But yeah, happy to jump into the questions. I can see there's quite a few in there. All right, I am conscious of time, so if we can't get through to your questions, I definitely recommend using that advice line on the QR code from before. But yeah, we'll just jump into the first question. Question for Katerina: how do I respond to my employee's request for casual conversion?
Yeah, so generally they just need to respond within 21 days of that request being sent, and tell the employee whether or not that request has been accepted. If you are refusing that request, of course, you need to let them know of the reasons why you're refusing them. And as I've said before, there may be a vast amount of reasons for that. If you're not sure how to articulate that, you're not sure what to put in the letter, we can, of course, help you guys with that. We can offer drafting resources as well. Things that you can find in the HRA Cloud do offer a great basis as a template. But if you need anything reviewed or anything drafted, we're also able to assist you guys with that. And we can also provide you some background information based on the information you provide us.
Wonderful. Thank you for that. We have another question around with the Victorian sick leave guarantee. So they wanted to know what jobs are included in that guarantee.
Yeah, so there's some industries that do offer this Victorian sick pay guarantee. As I've said, it doesn't include all industries. Generally, it would be things related to hospitality, retails, people working in supermarkets, food trades and food preparation industries, aged and disability care, their security, cleaning and laundry, and also sales.
Yeah, beautiful. Another question here. What does it mean to be a regular and systematic employee?
This is a great question and one that we always get actually, and regular and systematic is quite an elusive phrase, and it sounds simple enough, but it can be quite daunting when considering the hours your employees have been working and how that definition aligns with that. So it really just implies some form of repetitive pattern. It doesn't need to mean frequent or constant or even uniform. Those employees who are engaged on a regular basis may be constituted by frequent, I guess, unpredictable engagements as well. And the term systematic requires that engagement be something that could be called, a system, a method, or a plan. I guess that's quite self-explanatory, but the concept of engagement on a systematic basis doesn't really require them to have foreseeable or predictable patterns of work. It really can just be when their services are required. And oftentimes it will be sufficient that their pattern of engagement occurs as a consequence of an ongoing engagement between the employer and the employee.
Yeah, fantastic. I can definitely see more questions coming through, but we'll definitely go through what we can. Probably only have time for a few more, just being conscious of time. Again, if we can't get through to your question, we'll definitely have members of our team reaching out, but you also have access to that 24/7 advice line with the QR code from before. Uh, Next question, is casual loading accumulative, and do we calculate penalty rates on top of casual loading?
Yeah, so modern awards, as I've said, often have varying percentages, or they do have a 25% loading for casual employees, but they do have varying percentages for penalty rates. So generally, when applying penalty rates, I guess the easiest way to explain this is via an example. So let's just say a typical award provides for a 150% penalty rate on a Saturday. That 150% won't be applied to a casual employee's hourly rate, which includes the casual loading rate. It is applied to the minimum hourly rate for a permanent employee. So what you'll usually see is that the modern awards actually split the penalty rates depending on whether the employee is a permanent employee or they're a casual employee. What will usually happen is it'll say for a permanent employee that the penalty rate is 150% on a Saturday, but then for a casual employee, it will be 175% on a Saturday. That 175% is calculated to include that additional 25% casual loading. So that 175% is calculated on the minimum hourly rate for a permanent employee. What happens is if you apply that 175% to the casual rate, which already includes the loading, you'll have what we call double dipping, and they'll be receiving, I guess, an additional 25% on top of the 25% already included in that penalty rate. So in short, to summarize your question, the penalty rates are not calculated on top of the casual loading rate.
Yeah, perfect. Probably only have time for one more. A lot of the questions are looking quite specific, so definitely, again, reach out to the advisory service that we have. Last question, another good one. How can I terminate a casual employee?
Yeah, this is a really great question, and I guess another one that we do get quite often. It really does depend on whether that casual employee is still within their minimum employment period, whether they've been converted to a permanent employment when they are looking at being terminated. Generally, when an employee or a casual employee is terminated, there's no requirement to provide them notice. If the employee is having performance concerns and you're not sure whether or not they are going to meet the expectations of the business, I guess it really depends on your intentions. Do you want to coach them through that, enable them to improve over time, or have you seen enough and you're ready to let them go? If it's the fact that you want to assist them, you just need to really implement or look at implementing a performance improvement plan for them, and looking at guiding them through it. Otherwise, we would do what generally is termed or known to be as best practice. So, invite them to a meeting, provide them with 24 hours notice and a support person, as you will with the permanent employee, and really just explain to them the reasons as to their termination. Of course, it really does depend, and termination does depend on the surrounding circumstances. I guess there's always some element of risk involved with termination. So, for example, there may be general protections risks at play where the employee has been off on a period of absence because they're injured or they're unwell and they haven't been able to work. Of course, terminating them straight off the back of obtaining an injury may not always be the best idea. So it's quite difficult to advise on hypothetical situations. But if you're thinking about a more specific example in mind, please give us a call and we can assist you and guide you through that process.
Yeah, definitely can be a bit of a tricky one. But yeah, unfortunately, that's all we'd have time for today in terms of the questions. Again, definitely make use of our advice line, and I'll definitely get members of my team to actually reach out and make sure you're getting clarity on any questions you do have. But yeah, we hope you found today's information presented useful and practical, and hopefully you step away from this more informed than you were before. And yeah, hopefully we can see you at our next webinar. Thanks for coming.